Yes, Mr. My Lord. We were up the point of looking at the window which was provided for existing wholesalers to make their applications. And so far as my three clients were concerned, they made their applications early on in the window, and some 12 or so months after making their applications, the Revenue advised each of them that their application had been refused. And you'll see the the refusals themselves in Appendix Bundle 2A and 2B. One of them is at printed page 97, MS 304. That's the OWD one. The next one is in printed page, starts at printed page 273. That's electronic 480. And the final one is at printed page 277. That's electronic 484. And they all take pretty much the same form. And if I take as an example the one which my learned friend referred to, that's at printed page 273. That's the one in respect of Holland West. That's electronic page 480. We see it's dated the 19th of December. The application had been made on the 1 year earlier, on the 18th of December 2015. And we can see in the first paragraph there that HMRC allowed Holland West 1 month within which to cease trading. Now, there's no explanation in the letter of the basis on which HMRC was allowing Holland West 1 month extra, and the court will remember that under section 5412, the disapplication of section 88C1 only lasted until the application was disposed of. My learned friend this morning referred you to EN 2002, and in particular the version published on the 31st of March 2017. That's in Appendix 2C, starting at printed page 932. 932, and that's electronic page 1139. But of course, that post-dated this decision, and in particular, the versions that were then in force, or the version that was then in force, which is the one updated on the 21st of June, did not have such power. So quite what the source is, we don't know. Again, we've suggested the incidental power, but that doesn't find...
Well, the power, presumably, the power to exclude sales presumably already existed, but it hadn't been exercised.
Yes, the power to exclude sales is within the regulations, but it has to be exercised through the notice.
Yes. So the power existed, but it hadn't been exercised.
It hadn't been exercised. So returning to the specimen refusal letter, that's the one at printed page 273, electronic 480. We see the various points referred to by my learned friend as to why it was done. And then on the final page of the letter, printed page 276, electronic 483, we see what the threatened consequences are. And then they advise in that Holland West can ask for the decision to be reviewed, or it can appeal to the FTT, as we've seen the power is. And then there's a further criminal sanction mentioned in the penultimate paragraph of that letter. Having received the refusals, each of the wholesalers promptly appealed to the first-tier tribunal against the refusal, and also at the same time applied for expedition. And the court will see a sample of the appeal in Appendix, if we take the OWD one, Appendix 2A, printed page 105, and electronic page 312. And in this case, the notice of appeal was lodged within a week or so of the decision letter, and the application for expedition, the court will find at page 114 printed, electronic page 321. And you'll see there the appellant, this appellant is OWD, indicates in its grounds for expedition that it cannot, without authorisations, lawfully undertake its main trading activity. It will inevitably impinge upon its ability to trade, retain its staff and employment, and meet its outgoings and financial obligations. And absent an expedited and speedy hearing of the appeal, it's probable that the appellant's business cannot survive in its current form or at all. What then happened is, at the same time as having received the letter refusing approval, the appellants, each of them, sought a temporary approval from HMRC to continue wholesaling pending the outcome of the appeal to the first-tier tribunal. And an example or a specimen of such an application, the court will see in the relation to one of the appeals under tab 2B in the same volume, printed page 281, electronic page 488. And this is from Holland West. And we see, for example, in paragraphs 6 and 11 of that letter, Holland West explaining why it needed the status quo to remain pending the outcome of the appeal. The Revenue refused to countenance that, and in the case of this particular application, we see that in their letter on the 29th of June 2016, page 295 printed, electronic page 502. So pausing here, each of the wholesalers was facing the impending collapse of its business. Each of the wholesalers had a right of appeal to the tribunal, which it had exercised. Each of them had asked for expedition. But it's no criticism of the first-tier tribunal to say that with the best will in the world, those appeals were not going to be decided for months after the end of the grace period, the 1-month grace period that the Revenue had allowed. And so it was in those circumstances that the wholesalers, each of them, applied to the High Court for injunctive relief. And the court has asked earlier today what the form of that injunctive relief was. Page 297 printed, electronic 504, we see the judicial review claim form, and in the usual fashion, page 298, section 3, you'll see that the decision that gets challenged is not the refusal of the approval, it's the refusal to allow the temporary approval pending the outcome of the appeals.
Well, it was in that case. It wasn't in the others, as it happens, but it doesn't... there we are.
And then the injunction itself is sought in section 7. We see an interim injunction prohibiting the HMRC to prevent any steps from continuing their business, requiring the Revenue temporarily to include claimants on the Section 88D register, pending the determination of the claim for judicial review, And then they say a final injunction in the same terms as the interim injunction, but to continue until 28 days after the FTT issues its decision. So in the case of these three wholesalers, those applications for judicial review, the interim relief sought, which was sought both under Section 37, in the freestanding power of the court, and under Section 31 in its judicial review capacity, didn't meet with success in the High Court. And those judgments are in the core bundle, in the appendix to the core bundle, starting at page 238, printed, and in one case, and then in the other one starts at printed page 271. Sorry, and that is the electronic page reference as well.
Right. 238 and 271.
Yes, right down the end of core volume.
Oh, core volume.
So under the tab marked Appendix Part 1. So in both cases, the High Court saw itself constrained by the Court of Appeal judgment of CC&C, which introduced an exceptionality requirement and held that it's not enough that the decision was, quote, simply unreasonable, or that the appeal had a good prospect of success, or that the decision would, unless stayed, be fatal to the person's business. And so with that gloss poured over the High Court's Section 37 jurisdiction, the judges declined to grant an interim injunction to assist, as the appellants would have it, the FTT in the performance of its review functions. So it was only when the matters went to the Court of Appeal that interim injunctions were granted, and my learned friend has referred you to those. We see them in Part 1 of the appendix. We've just been looking at, starting at page 82. In one case, see the injunction there. And then 84 in the other case.
Sorry, what are the electronic pages?
Electronic page 289 and 291. And it's the case that in relation to the 26 other wholesalers, it was the High Court, knowing of these injunctions in the Court of Appeal, or knowing of these three lead appellants, granted injunctions in materially the same term, and that's why they are, as it were, stood behind these appeals.
So the Court of Appeal went one step further than what was asked for in the Judicial Review Claim Form. The Judicial Review Claim Form didn't actually ask for approval, it asked for registration using the same language as if you'd been approved. Whereas here the Court of Appeal specifically requires, by way of mandatory order, a provisional approval.
It does. It's
That follows, doesn't it, from the fact that instead of basing this on Section 9, they based it on Justice Burnett's view of 288C.
We were having it both ways.
No, because this is before the Court of Appeal's decision, isn't it?
It is.
But your draft injunction is, I think, the one you took us to is 2B, Appendix 2B, hard copy 321. I'm afraid I haven't got them.
I've got it at, I think,
Electronic number.
506.
How many?
Yeah,
506 is on the claim form.
506.
Thank you, 506. And what you were asking, what you were then suggesting, was an order not to take any steps to effectively to impede business and to add to the register.
And as my lord says, what the Court of Appeal eventually did in both these cases was slightly different.
It was.
There wasn't any hearing, that I take it. No
Not
judges
for-
identified, and
Not in the Court of Appeal, my lady. There was obviously, when we were unsuccessful in each of the High
Well,
Court.
the Court of Appeal judgment records the first one was Lord Justice Burnett, as he then was, and
Yes,
the other
that's
was
right,
the other was Lady Justice Thirlwall, who simply followed suit.
Yes. So all of this happened in early 2017, and I was asked shortly before the adjournment where have the appeals got to in the tribunal. Now, so far as we're aware, apart from an appeal which the court has in its bundle, volume 2, tab 17, which we'll get to in a moment, none of our appeals, or indeed the other 26 appeals to the first tier tribunal where there is an injunction in place, has yet been heard, let alone determined. And there's a reason why 18 months have elapsed with no hearing. And that reason is that early on in the piece, the FTT made disclosure orders against HMRC in order for that tribunal to resolve the appeals. What happened then was...
That's directed at the history of alleged defaults, is it?
Yes, so getting to the bottom of that, HMRC then applied to the tribunal, the FTT, for those disclosure orders to be set aside. It was unsuccessful, and the tribunal's reasons for that, this court has in Appendix 2A at printed page 241, electronic page 448. HMRC then appealed to the upper tribunal against that decision. Pending the determination of that appeal, that's the Revenues Appeal, the FTT stayed the appeals before it, and in December last year, the upper tribunal dismissed HMRC's appeal, and that judgment or decision the court has in the bundle of authorities, volume 2, tab 21, electronic page 1747. So that's Mr. Justice Henry Carr and Judge Charles Hellier.
1747.
1747.
Thank you.
HMRC then sought permission from the Court of Appeal to appeal against the upper tribunal's decision. So far as we are aware, that application for permission remains pending. But in the meantime, the Revenue applied to the FTT for a further stay of the appeals pending the outcome of that application. The tribunal refused, and as we understand it, HMRC then advised the tribunal that they would take some 6 months to complete their disclosure. There is now a further hearing listed before the FTT on the 30th of July this year to determine whether the amount of time claimed by the revenue to be required for disclosure is a reasonable one. Now, the reason I have descended into this procedural history is twofold. First of all, to make clear that these two appeals have an immediate importance to a significant number of other established wholesalers and, of course, to their employees. If the wholesalers' appeals to this court are dismissed and the Revenue's appeal is allowed, it is the Revenue's position that those wholesalers will have to immediately cease their duty-paid wholesaling business, and all their stock and that of their group companies becomes subject to forfeiture. That is the Revenue's position, regardless of the strength of their respective appeals. That is their position, regardless of the time that it will take for those appeals to be determined. That is, regardless of the reasons for any delays in the appeals being heard. And it is regardless of the consequences for each of their businesses and their employees. And secondly, the history serves to explain why the wholesalers in these appeals, despite securing a measure of success in the Court of Appeal, have had to appeal to this court to make the success worthwhile. Because in recognising that HMRC had power to grant a temporary approval pending the outcome of an appeal to the FTT, the statements of principle that the Court of Appeal attached to the exercise of that power diminished its usefulness. And indeed, on HMRC's reading of the Court of Appeal judgment, it diminished its usefulness to vanishing point. It gave with one hand and took away with the other. And the critical paragraph to which my learned friend has taken the court and which vexes us is paragraph 54 of the Court of Appeal's judgment. That's in core volume electronic page 225 under Appendix Part 1. And there, as my learned friend pointed out to the court, it is stated, hardship and the impact on appeal rights would be extraneous considerations. And in the following paragraph, the court cites Mr. Eady as warning that even if this power existed, it is theoretical and unlikely to be exercised in favour of an applicant who has failed to satisfy HMRC on the broader basis. That is as may be, that it is a power which the claimants were entitled to expect HMRC to consider using. So it is of cold comfort to these wholesalers, and indeed the others one can conjecture, to say or to be told that the Revenue must make a decision, but that in making that decision, HMRC can shut its eyes and block its ears to the hardship resulting from the decision and to the impact of that decision on the right of appeal. It is our position that hardship and impact on appeal rights are highly relevant considerations to this decision. When Parliament confers a right of appeal against decisions made in a statutory regime, it is to be supposed that Parliament intends that that right is to be an effective right. And where there is a power to make decisions within that regime, we say that faced with a choice between making a decision that will leave effective the appeal right and a decision that will leave pointless the appealed right, it is unprincipled to assert that the effect is an extraneous consideration. That's what Parliament really wanted to do. We say it needed to say so in unmistakably clear language.
I'm sorry, can I just ask you, I think you're moving away from the narrative of the facts that you gave us a few minutes ago. You prefaced that narrative by saying that none of the appeals to the FTT where an injunction is in place has yet been heard. I just wondered, does that mean there have been appeals heard where there was no injunction in place?
There has been one, and it did have, it applied for an injunction, but it was unsuccessful. But it got its appeal up and running before the tribunal very promptly, and we see that decision of the tribunal in Authorities Volume 2, and it merits consideration. It's under tab 17, electronic page 1546. Apart from this, not that we're aware of that has an injunction.
This is a fairly substantial decision, isn't it?
This is a decision, and it's a decision in which, at the end of 117 pages, the appeal was allowed. And I mention it because my learned friend this morning said that the revenue is particularly well placed to make these judgments, citing CC&C. And this decision casts that assertion in doubt. We look at paragraph 2 of the judgment, starting at page 1547. We see it's a long-established business, starting in 1965. It's a family business. We see paragraph 4, the reasons given by the revenue for refusal. Then there's setting out, starting at paragraph 6 of the legislative framework. And if we turn to electronic page 1551, there's a summary of the decision. They're given in paragraph 15. And they direct that the decision shall immediately cease to have effect on the basis that the revenue shall conduct a review of the decision as set out in paragraph 404 below. We see that there were serious disclosure issues which the tribunal considers. And then if we turn to page 1624, that's internal page 79. You see some of the issues that were here raised at paragraph 322 of the judgment. We accept at CW as Corbelli's submissions, essentially that there are a number of factors indicating that Mr. Germany, that's the revenue officer, did not engage properly in the decision-making process. He was uninterested in what explanations Corbelli might have for his grounds of refusal, and he was influenced by an oblique motive as he had moved jobs and was in a hurry to complete the decision-making process. This is what Sir James Eadie would say we should have respect for. And so it goes on throughout, and they consider one by one the bases in a very careful and thorough decision. So we say this is the very reason why protection is required. This was a business which was going to, a long-running business, which was going to be destroyed by the decision of the revenue. So,
yes, this one was heard. The hearing was at the end of May, and the judgment seems to have been produced very quickly.
released in August.
Yes, was there no... Was there it was a difference really that there was no major issue about disclosure?
There was an issue about disclosure, which we see starting at electronic page 1551, paragraph 16.
Well, whatever the disclosure arguments must have preceded the hearing.
Yes.
Correct.
Yes.
Quite a lot of it was complaints of some, or at least some of it was complaints of suggested procedural impropriety, wasn't it? Where you were taking us just now, around the 320s.
Yes, I mean, part of the disclosure issue was a claim of public interest immunity by the Revenue, and you'll see that
That's
picked up right at the end of the decision. But beyond what's in the decision of the tribunal itself, I don't know how it was progressed and what the principal issues were. I didn't take part in it.
Yes. Yes, thank you very much.
But that's, as I say, the backdrop, the factual backdrop. And we say that the Revenue does have power to temporarily approve and register a wholesaler refused approval pending the outcome of that wholesaler's appeal to the tribunal against refusal. Our preferred location for that power is the incidental power in Section 9 of the 2005 Act, which we have in the bundle, and we'll get to that in a moment. But we recognise that logically one needs first to see whether Part 6A of the 1979 Act, ALDA, itself allows the Revenue to temporarily approve and register a refused wholesaler. Only if, or to the extent if, Part 6A does not so allow, does one need to turn to the incidental power. So the point we stress is that if this court were to uphold the Court of Appeal's judgment, both in terms of there being a temporary power and in terms of the limitations on that power, then it's the wholesaler's position that the incidental power remains available to temporarily approve and register a refused wholesaler unconstrained by the limitations identified by the Court of Appeal in relation to the Section 88C power. Now, so far as the 88C power is concerned, there is, as we've heard this morning, a measure of agreement from the Revenue as to their power to grant temporary approvals. And we see that also in the Revenue's printed case, or written case, in core volume, starting at electronic page 109, but specifically starting at electronic page 125, paragraph 54, paragraph 55, 64.2 and 66. What remains between us on the Section 88C power is HMRC's contention that their power to grant a temporary approval can only be exercised to take account of some anticipated future change in circumstances. And we say there is no reason to read in the restriction contended for by HMRC. HMRC, we say, get the wrong answer because they ask the wrong question. And time and again, the question posited by Sir James was that the issue to ask itself was whether the person was a fit and proper person to wholesale duty-paid alcohol. Well, with respect, that's a pigeon way of expressing the question. And the key to it lies in the linkage between subsections 2 and 3 of Section 88C, which, if we go in the authorities volume 1, tab 1, electronic page 1181, we see how the two provisions work as a pair. And the critical issue is this: the decision whether HMRC approve a person under Section 88C falls to be decided by reference to whether that person is a fit and proper person to carry on a controlled activity for a particular period and subject to such conditions and restrictions as the revenue think fit. That is critical to an understanding. That is the question to be asked. There is a dynamic between the two subsections, with the conditions and the time period influencing the decision to approve, so that the revenue might well consider that a person is fit and proper to carry on a controlled activity subject to conditions or restrictions, while considering that the same person is not fit and proper to carry on the controlled activity without the conditions or restrictions. And similarly, the revenue might well consider that a person is fit and proper to carry on a controlled activity for a limited period, whilst considering that that person is not fit and proper to carry on that activity beyond that period. For example, it might say, we want to confine your approval to 6 months to make sure that we build up your trust in you, or that we are tentative in our approval of you. We're not going to give you an unlimited approval.
But that's the revenue can't withhold registration approval on the ground that it thinks that somebody might prove to be not fit or proper. It's got to be satisfied that it isn't fit or proper. So I'm not quite sure how this fits into the scheme. I can see that you might have some conditions which would go to the fitness or properness of the candidate. This is the point which I discussed with Sir James Eady in an interchange this morning. But if you're looking at a period of time, you've got to establish, haven't you, that there is some difference between the facts going to the fitness or properness of the candidate during the period you're prepared to allow him to do it, and during any subsequent period when you're not prepared to allow him to do it. Otherwise, it's not relevant to fitness or properness.
I accept that, and the change in fact is that it has performed over those 6 months. So you could have, to pick up the suggestion made, a set of conditions that says, in this period, in this opening period of 6 months, we want you to report every wholesale sale you make in a spreadsheet once a week, electronically sent to such and such an officer at the revenue, so that we've got a complete view of what you're doing. Or, for example, that you have CCTV footage of everything coming in and everything coming out, which is what happens in the duty suspended world.
Well, that's a scheme that you're proposing to enable them to change their mind, which they can do anyway. If they conclude on the 1st of January that somebody is not fit and proper, if they were to do what you're proposing, all that could establish is that there were grounds for revising that opinion in the light of further information over the next period of however many months.
Well, two things. First of all, the risk is being managed. It's being managed to a level where it becomes acceptable to the revenue. And secondly, the longer a person is approved, and particularly if there's no temporal limitation on the approval.
The risk of what?
The risk to the revenue of the things that they apprehend might happen, i.e. that they will...
What, non-payments of duty, frauds or whatever?
No, it's not the non-payments of duty, because these are duty-paid objects. It's the trading with people who are suspect. What's sought by this regime is to cut off the market for people higher up the chain who are considered to be suspect. The idea is to cut them off by getting duty-paid wholesalers to avoid them and to stick with people who they can show to the revenue are to be relied on. So the way I characterise it, possibly an exaggeration, but there's a slight element of conscription to it. It's helping the revenue in the fight higher up the chain. That's what's sought to be done, and it's an iterative process where, as more is learned about the way that the fraud operates higher up the chain, different things can be expected. That's the risk that's being managed.
But I mean, haven't you got to distinguish between the question whether somebody is a fit and proper person and the question whether the risks of his being unfit and not proper can be managed? Because the former is the relevant statutory question, but the latter is not.
Well, we say that the question is whether the person is fit and proper with the conditions and the limitations imposed. The two things in one. It's a shaped fit and proper. It's not fit and proper in a vacuum forevermore without conditions.
But wouldn't the conditions and restrictions have to bear on the fitness and properness of the person? I mean, if leaving conditions and restrictions out of account, the person is not a fit and proper person, which is obviously the revenue's conclusion in relation to your clients. You're arguing that with appropriate conditions and restrictions, they could then be regarded as fit and proper persons. I would have thought for the conditions or restrictions to have that consequence, they would have to turn somebody who wasn't fit and proper into somebody who was. And so they would have to bear on their fitness or properness, as, for example, if the condition was to employ or not to employ a particular manager.
We say that a person is fit and proper, having regard to the conditions. In the same way, in many other regimes, you might be fit and proper to drive a certain class of motor vehicle, but not another class of motor vehicle. And what's being done here is you're saying you're fit and proper, subject to these conditions, subject to this temporal limitation, not at large, in the same way that because you can drive an automatic motor car, you can drive an HGV. The fitness and propriety takes its measure from what the person is being certified as being fit and proper to do. So there's a linkage.
Really, it amounts to saying you are fit and proper enough to have you do it for the limited period until the appeal comes along, but not beyond that. That's it in essence.
That's what we would say.
But the trouble about that is that most of the conditions will relate to the operation of the business. What you're wanting to be taken into account here is the consequences of the ceasing to operate of the business, which is not the same question at all.
No, it isn't. And I've already indicated that we do say the consequences to the business and the consequences to the appeal right are highly relevant matters. They're not determinative. They don't necessarily mean that you get through, but they are a legitimate consideration.
But they are qualitatively different from the sort of conditions which would concern themselves with the operation of the business.
Yes, in a fashion, they are qualitatively different, but I don't say that that is determinative of the answer. There's a whole series of things we say that fall to be taken into account, but what can't be erased from consideration is the effect on the business, how long it will take, the effect on the employees, and the effect on the appeal right.
At the moment, I'm afraid I just don't see how those considerations are relevant to an assessment of fitness and properness.
They are, because we say the person is, first of all, not going to be approved forever. Secondly, we say that the determination that the revenue has made that the person is not fit and proper is one which, of course, is subject to review, and as we've seen, may be overturned by an independent tribunal considering the matters. And so once you start taking into these considerations into account, and also bear in mind that it's possible to impose other conditions and restrictions which will manage the risk to the revenue as it perceives it, we say it does have the power. We have always preferred to root it in Section 9 rather than Section 88C.
Yes.
But whether you root it in one or whether you root it in the other, the nature of the exercise, we say, is the same.
Well, let me just have one more go, maybe going over the same ground again. Just supposing that the one were with you in saying that somebody might be, that you can only judge whether someone is fit and proper by asking whether he or the company would be fit and proper given the conditions which are supposed. Just supposing that's all right. How does that enable you to say you're fit and proper to operate for as long as your appeal in front of the first-tier tribunal may take, but not thereafter?
Well, it only works because we say it is a relevant consideration that a person has an effective appeal right. If you strip that out as the...
Well, that's circular, isn't it? That begs the whole question. Doesn't it?
Well, certainly if, as the Court of Appeal did, you strip that out, you, as I have put it, take away what's been given with the other hand.
Yes, that's all right.
That's why we have that difficulty with paragraph 54. I mean, I have to face it, and that's why we've rooted it in Section 9. That's why our preference. I know my learned friend teased me about being a reluctant horse going to water, but I looked at what was in the water. You're just as reluctant
today.
Still don't like the look of it, do you?
Yeah, as pointed out, we see the Revenue's own fitness and propriety test, which we see in Appendix 2C, printed page 659, electronic page 866, recognises in the middle of the page, you must consider applications in the light of their suitability to be approved. This includes a judgment on whether what is known about any person or persons associated with the business reasonably suggests a significant real or potential risk to the revenue. And there's a reference to having to act reasonably and proportionately in relation to conditions, restrictions and requirements.
But I mean, this, what you're submitting is that conditions which have nothing to do with the fitness or properness of the company or the individual may mean that although not fit and not proper, there isn't a real or potential risk to the revenue because of, e.g., your proposal for weekly spreadsheets. That's the point you're making.
Manage it, yes.
I mean, there's a very familiar jurisdiction where the courts are dealing with this all the time when it disqualifies a director on the basis he's unfit to be concerned in the management of a company. Almost inevitably, the director comes straight back and says, well, can I manage my family company on certain terms? And the court assesses whether those, with the assistance of the official receiver, whether those terms sufficiently protect the public dealing with the company. It's practically similar, although it doesn't impact upon whether he's unfit. I think he is, by definition, he's found to be unfit.
Yes.
But it's,
The
it
disqualification is qualified.
Yeah.
Yeah.
I mean, there may be a difference between the judgment that one has to make when considering the fitness or properness of the candidates at the outset. Suppose you say, this person can't be relied upon not to present a real or potential risk to the revenue, so you say no approval. You're then saying that subsequently he may be the same person, but controls may be added to the scheme, which mean that though he hasn't changed his spots, there's less that he can, in the way of damage, that he can do.
It's been caged. The leopard has been caged.
Yes,
Yeah,
yes.
or muzzled.
I mean, my instinct is that it's a bit hard to fit into an extremely elaborate scheme like this, which makes it unlawful to sell wholesale, or indeed to deal with a person selling wholesale, when the relevant conclusion has not been formed by HMRC before the decision was taken.
We've seen that the revenue itself, having made that decision, then allowed a grace period.
Well, I mean, I very much question whether that's consistent with their own submissions about the law.
There's a real issue there.
Well, there's a real issue on which it seems to me to be very, very difficult for the Inland Revenue to justify their position. It doesn't matter now, because since the 31st of March 2017, the excluded sales provision has been applied to the rundown sales. But I mean, one assumes that the reason why they did that is that they may have had a certain amount of collywobbles about the legal basis of the transitional period. But whether they had collywobbles or not, they jolly well should have done.
Yes. But as I've foreshadowed, if we are wrong about the Section 88C power, or if it's limited in the way in which the Court of Appeal said it was limited, then we say that Section 9 of the 2005 Act confers the necessary power.
You say that goes wider because it's not tied to the finding of fitness and properness.
Correct.
Is that it?
That's essentially, but can I do it full justice by looking at the provision itself, which is in the authorities volume, tab 4, electronic page, page 1289. You'll see ancillary powers. The commissioners may do anything which they think, A, necessary or expedient in connection with the exercise of their functions, or B, incidental or conducive to the exercise of their functions. And functions itself is defined in Section 51, which you have at electronic 1315, means any power or duty, including a power that is ancillary to another power. And so just looking at the terminology used, the provision is, we say, as wide can be, and indeed is considerably wider than others that are more familiar to maybe more familiar to this court, for example, under the Local Government Act and what have you.
What do you submit is the relevant function?
Well, the relevant function is the functions that are in Part 6A, but the question is it incidental to those functions?
Just identify the function in this quite elaborate scheme to which you say that a power to allow interim relief of some sort is ancillary.
It's the power to grant an approval, and it's the power to grant an approval in the context of a regime that expressly includes within it a power to go to the revenue for a right of review, so a review power, and a power and/or a power to appeal to the tribunal itself.
And what form of intervention do you envisage that that HMRC would register somebody on a provisional basis? Is that the form? Is that the way they would exercise this power?
Yes, would register the person, and essentially temporarily approve or treat as if it were temporarily approved a person. So none of the sanctions for trading without approval.
So it's not simply refraining from enforcing the scheme against them, it's actually giving them a registration as if they were fit and proper, even though they're not, in the revenue's view.
Correct.
I mean, how do you say that it can be ancillary, or incidental or conducive to the exercise of a function of granting approval, to grant it contrary to an express condition in the relevant statute?
Because it makes effective the review and appeal scheme that is an inherent part of the whole regime, introduced at the same time. And we remember that it's the revenue which exercises the review function. So in exercising the review function, there's no point in their having that function under the Finance Act 1994 if the thing itself has gone into insolvency.
It may make that effective, but it makes completely ineffective the provision that they may approve only if they consider the person to be fit and proper.
Yes, I mean, one only gets to an incidental power if the primary power itself doesn't exist.
Well, sometimes that's because of an absence of it, but here there's a contrary provision.
This is a provision that supplements the exercise of a power, but you are using it to replace that exercise of a power and substitute the exercise of a power on a basis completely inconsistent with the primary power.
Well, we don't accept that it's completely inconsistent. If the provision had said HMRC must not approve a person in these circumstances, then that would contradict.
It does say that, doesn't it? It says it may not register them unless, which is an exact, I mean, it's putting it in grammatically the other way around, but it means exactly the same thing.
Well, the proscription is in 88C1, and that's prescription is on the person, and the disposition of power is given by 2 and 3, and it says under those provisions it may only approve a person only if certain conditions are satisfied. Necessarily, we only get to the incidental power if there is an absence of power in subsections 2 and 3. I accept that. One doesn't need an incidental power if it weren't there. This is not a proscription on freestanding prescription on the revenue granting. This is simply delimiting the power. It's a delimited power. And we get to
there's a world of difference, isn't there, between using an ancillary power, and this Section 9 power is in a form found in many statutes. There's a world of difference, isn't there, between using an ancillary power to fill a gap and using it to suspend the effect of a mandatory provision in the Act.
I think there's, from recollection, there are a number of tax cases on this point to do with the use of Section 9 to make extra statutory concessions, and the problem that's emerged being where the concession actually contravenes a statutory provision, or means that the revenue are failing to carry out their statutory duties.
We deal with this in our written case, and the distinction that emerges from the various cases on incidental powers is a sharp distinction between where Parliament has provided that certain matters are to be charged for or a tax is to be imposed. You can't use the incidental power to get around that. And there are a whole series of good constitutional reasons behind that. In other circumstances, really what's going on is essentially a Padfield type exercise, and that is to say, is the purpose and object for which this incidental power is being used consistent with the overall purpose and object of the statutory scheme? And you don't just hone in on the individual provision itself. You look at the whole scheme as one and ask yourself, to to use the phrase by my Lord Sumption, is it filling a gap? And we say this is a gap. I mean, this is a real gap, that you have people who have been given a statutory right of appeal and that statutory right of appeal and review is being negated, made worthless, because they aren't in existence unless there is some mechanism in place to maintain the status quo.
But it isn't a statutory gap. I mean, there may be a gap in the sense that a power that might be thought desirable just isn't there. But the problem here is there isn't a statutory gap because the gap is filled by a positive command that they are not to register the person.
Well, we read 82 in 3 as being a circumscribed power rather than prescriptive. And what it is doing is delineating the circumstances in which the commissioners may approve a person. And the question is, to revert to Padfield considerations, is whether the incidental power used in the way that we have asked and suggested is looking at these two provisions and the whole statutory regime inconsistent and in defiance of the object of the scheme. It comes to that ultimately. And it's certainly right that one does concentrate on the two subsections, but that's not the only series of provisions that one must look at. One must look at the totality of the scheme and ask oneself, is there any power, is it incidental to say that this power can be exercised in this fashion? Because plainly, if all you do is look at subsections 2 and 3 and say the power is not there, then you're going to yield the same answer whenever you get to a consideration of the incidental power.
Which is the best of the cases, Mr. Koppel, for saying that where a general ancillary power has been found, even though on the face of it it's inconsistent with the primary statute, which is the best one? I mean, you've got Padfield and Spathholm and one or two others.
Well,
Does any of them get anywhere near what you want?
That's
You want one, don't you, where someone has said, well, it may well look as if it's excluded, but once you consider the statutory scheme as a whole, it's plain that this is a necessary power which must have been intended. That's what you're after.
Yes, that is. I mean, we make the point, it's electronic page 177.
That's it, yeah.
And we see the baby products case at 92B. The question is whether the particular use of a power would defeat the statutory scheme as a whole.
I've got the as a whole point. What I'm after is something where is a case where your best case where the as a whole consideration has prevailed against what appears to be a statutory prohibition.
We haven't been able to find a particular instance. I'll be candid about that. Not because we've found instances against us. It's just there's remarkably little. And many of the cases on incidental power have revolved around attempts to get around statutory controls on expenditure, which this is not, of course. That, as we say, is the second source of power. But whether the power be sourced in Section 9 or whether it be sourced in Section 88C, the question then becomes how that power ought to be exercised. And in particular, what are the considerations the revenue should take into account when making the decision to grant a temporary approval pending the outcome of an appeal to the first-tier tribunal. And as I said, we do take exception to the passage in paragraph 54 of the judgment of the Court of Appeal that hardship is irrelevant. We say that it is highly relevant. They're not extraneous considerations. If there is such a power, the temporary power, then whether it's in Section 9 or Section 88C, the exercise of that power should be directed to ensuring the effectiveness of the wholesaler's right to have its appeal heard and decided by an independent and impartial tribunal. And my learned friend suggested this morning that we necessarily root that in Article 6 or Article 47 of the Charter. That's not right. We put in our printed case, it's page 159, it first and foremost on common law interpretational principles, which we set out at paragraphs 35 down to 44. And the first of those is that which is stated by Lord Diplock in the Times newspaper case, and that is that the due administration of justice requires that all citizens should have unhindered access to the established courts of criminal civil jurisdiction, to which we might add the tribunals, for the determination of disputes as to their legal rights and liabilities. And whereas we say Parliament has conferred a right of appeal to an independent tribunal against an administrative decision, Parliament has decided that that's the case because it's in the public interest that that right should be given effect. It's not just a private law matter, it's a matter of public concern. And so we make it quite clear that we don't fall simply on Article 6. Our first port of call is relevant common law interpretational principles, which we say should colour the interpretation to be given to these principles, to these provisions, and how they are to be operated. So the next point, my final point, is learned friend suggested this morning that holding that the revenue had a power to grant a temporary approval would lead to no end of practical problems, including an endless cycle of appeals. Well, that's not the way it would work. It's not even the way it would work under Section 88C. And we set out that in our printed case, electronic page 172, starting at paragraph 78. Because whether a wholesaler asks for a temporary approval with their main application, which is a bit unlikely, or subsequent to the approval, the refusal of that is in fact a variation of the decision that then gets appealed, or that is appealed to the tribunal. And it's perfectly open for the tribunal to split the two decisions, or to split the two facets of the decision, and to say, we're going to look at the temporary approval aspect first, and we can decide that as a preliminary issue on a summary basis or a faster basis, and leave till later the longer term decision. So it doesn't lead to an endless cycle of of appeals. It's a single appeal, which we say the tribunal is well capable of dealing with. And we say that the tribunal will, in carrying out its exercise on the short-term decision, be mindful of its obligation to ensure that the appellant wholesaler has an effective right of appeal. It will be mindful of the risks that the revenue point to in the making of its decision in the short term. And in that way, we say it's a perfectly viable and practical scheme in which the two competing considerations are given full effect to. So there isn't any of the problems, as I've said, that have been pointed to by Sir James this morning. And we say whether you root it in Section 9 or Section 88C, there is that power, and the way in which that power ought to be exercised is that which we have set out, namely, so far as the temporary decision is concerned, what should be driving the decision is to ensure that a person has an effective right of appeal to the tribunal, having regard to the interests that are at stake for the appellant and, of course, for the revenue itself. My lords and my lady, unless there are further questions.
Thank you very much indeed, Mr. Coppell. Mr. Bednam, do you follow?
There's just one point I wanted to raise.
Yes.
Mr. Coppell raised that the fit and proper test isn't to be considered to be some nebulous concept. It's coloured by the scheme to which fit and proper applies. And of course, the revenue has set down its own guidance on how it will approach fit and proper, and that's in Appendix Part 2C, page 659, MS page 866. And we see that the revenue say, under the heading fit and proper test, that the aim of the fit and proper test is to ensure that businesses who present a risk to the revenue are excluded. And it's then said that the officer must consider whether the business poses a significant real or a significant potential risk to the revenue. And then later on in the paragraph beginning, in any case, we see the key test to be applied in any case is whether, on the balance of the evidence, you believe that approving the application is likely to create a real risk to the revenue. Well, in assessing whether someone is fit and proper for AWRS then, the revenue have to assess what level of risk the trader poses to the public revenue, because it's only if they get to the significant level of risk that they stray into the not fit and proper camp.
Well,
And the length
it's a test of their, in most cases, of their character, isn't it? It's asking, are these the sort of people whose business operations present this risk? This is a characteristic of the people rather than a description of the way the business is run.
No, I think that is right, because lots of AWRS decisions are taken not on the basis of you're a bad person, you're not a fit and proper person, but rather your due diligence procedures, your mechanisms, the way you conduct your business aren't up to scratch. You haven't put in place appropriate controls. So the length of time for which someone is permitted to trade must be a relevant factor in determining the extent of risk to the public revenue.
That would be a classic instance of a case where conditions might make a difference. If the sole objection was that their due diligence procedures were unsatisfactory, I can see that you might say, well, you could have a conditional approval, conditional on that being rectified. But if you take the kind of objections that have been advanced by HMRC about these particular companies, they're not quite so easily dealt with on that basis, are they?
Well, my lord, I accept that if it's said that a given wholesaler is knowingly buying and selling alcohol on which duty hasn't been paid, then that person is likely to present a risk for the revenue, regardless of how short the approval, a significant risk.
Well, he has a track record of defaults of one kind or another.
Indeed.
Which is an allegation made, I think, against certainly at least two, and it may be all three of these parties.
We can look, if need be, at the reasons given. But I accept that for a wholesaler that is knowingly engaging in buying and selling duty-paid alcohol on which duty hasn't been paid, that even a short approval will constitute a significant risk to the revenue. However, if the objection isn't you're knowingly engaged in that sort of trade, but rather your procedures are more lax than the revenue you want them to be, then it must be the case that the shorter the approval the less risk to the public revenue there is. And so in those circumstances, a person that it might not be appropriate because of the significant risk to the public revenue to approve indefinitely could properly be approved for a shorter period.
Well, he would present the same risk, but the financial consequences would be smaller the shorter the period during which he is allowed to roam in this risky fashion.
Well, that's, remember the guidance is significant risk. And the longer...
The risk would be the same, it would just operate for a shorter period.
Well, my lord, if it comes down to there are concerns that your due diligence isn't always up to the requisite standard, not on every trade that you do, but on some of the trades, the longer the person is allowed to trade for, then the greater the risk to the public revenue must be. And conversely, the shorter the period allowed to trade for, the lower the risk. And it's in those circumstances, my lord, that I say that the length of time of the approval is relevant and does go directly to the fit and proper test.
Does this guidance that we're looking at deal with the sort of conditions that might be imposed?
I think it does.
Variations and conditions, I see, starts at page 663. Is that the relevant section?
Yes. I'm not sure if there are any suggested conditions in the guidance.
Well, there's a due diligence condition referred to at 665, which is a condition of, that seems to be a standard condition of approval.
It is, my lord. So what happened was there was a public notice, section 10 of the public notice added in a due diligence condition to apply to everyone's approvals. So
yes.
All approvals have the due diligence condition.
Yes, so presumably, if you refuse approval, it's because you are not confident that that condition is going to be observed, at least in the case where due diligence is the only problem.
Yes. And going back to the test as the revenue apply it, does this person constitute a serious risk to the public revenue? A person that has inadequate due diligence for multiple years may constitute a serious risk, but if it's time limited, then the risk is necessarily itself constrained.
Is there any help for you on the question of conditions at 655?
Well, I'm grateful.
Oh, I'm sorry, I don't know what it is. What's that electronically?
862.
Thank you very much. It's only examples, but they seem to contemplate, and it's in the context of the giving of approval.
Yes.
So what seems to be contemplated is giving approval subject to additional conditions or restrictions, some examples of which are given.
And that ties in as well, because it may be unrealistic to impose certain conditions on an indefinite basis because of the resource implications both for the trader and for the revenue in looking at, for example, whatever further documents are submitted. But if it's on a time-limited basis, then it may be that these sorts of conditions are more readily workable. So if we're only looking at an approval for 6 months, pending appeal, then it may be that a requirement to provide extra documentation to the revenue is workable and allows the revenue the comfort that they would need to allow a trader to continue for that fixed short-term period.
I see the note underneath. You should not use conditions on an applicant's approval as a substitute where the risk to the revenue justifies that refusal or revocation would be the appropriate response.
Yes. But the question then becomes...
presumably the fact that they may impose these conditions indicates that if they decide to refuse, it's because they don't think that the imposition of the conditions will be good enough.
Well, that must be right. But again, whether a condition is appropriate to deal with a level of risk is coloured by whether the approval is time limited or indefinite. Well, the only other point I wanted to raise is, in terms of a mechanism, how HMRC could allow traders to continue pending appeal. They could, of course, say that sales made by a given trader are excluded sales, and that would be a mechanism.
All of them.
Well, the concern is that HMRC don't have the power, having reached the conclusion that someone's not fit and proper, to then approve them under Section 88C. But what they could do is declare that where a trader has been denied approval, has appealed, and where whatever the threshold conditions are, that any sales made by that person pending appeal are excluded sales. So that would be a mechanism which would allow HMRC a power to achieve the result of that sort. Was there the only points I wanted to raise?
Thank you very much. James.
My lords, my lady, I can be very short, I think. The first group of points perhaps relates to the facts, and simply to put down a note of caution. I obviously can't address the particular circumstances of a 400-paragraph judgment of the FDT, but it's a different case. My learned friend sought to use it, I think, for the purpose of suggesting that when I suggested that these were decisions which the revenue was particularly well placed to make, that was, as it were, undermined by an adverse decision in a single case. You'll understand that I don't accept that proposition at any of its stages. I don't accept that that demonstrates anything more than that the FTT exercises the jurisdiction which statute has given to it. Nor, I may add, do I accept that that is my point. It's a point, with the greatest respect to him, that Lord Justice Underhill made in paragraph 15 of C, C and C. You will also bear in mind, in relation to the description of the facts and why cases have got to where they've got to, that, as I think the questions that my Lord Reid asked indicated, the cases or the cohort that my learned friend sought to select for the purpose of demonstrating unconscionable delay, I think that was the thrust of the point, were all cases in relation to which an injunction was in place and has been in place throughout. And that obviously has some implications for the possibility of the FTT exercising the powers that it has. If there are already High Court or Court of Appeal injunctions in place, that might act as rather a dampener on them doing other things. But I'm asked finally to point out that, at least in relation to Holland West and the related client, at least some part of the delays appears to have been not to do with the revenue's position at all. The latest delays appear to have occurred, I'm told, because those parties have been late with their evidence. And there is an extension of time for them to put in their evidence by the end of July as the latest extension. So I don't want you to be left with the impression that it's all one way, as it were, in relation to the conduct of the underlying litigation. That's all I wanted to say about the facts. So far as Section 88C is concerned, it appears from the way in which my learned friend has ultimately placed the argument under Section 88C that the critical feature, so far as that argument from his perspective is concerned, is whether he can get hardship back in. It was stripped out by the Court of Appeal, as we know, in paragraph 54, and the essence of his argument was that he didn't like that, and he wanted it and needed it for this purpose back in. And of course, at that point, the argument to some extent ran into the sands, because it began to look remarkably like the argument he was running under Section 9. And so there are difficulties with that. What he didn't do was to address the submissions that I made in opening this appeal, which started from the premise that the Court of Appeal was right to treat hardship as an extraneous factor under Section 88C. And if that is the position, you then have to confront the problems that I identified in opening. It's no good just ignoring them. If hardship is out, what is the content of the discretion? How does it work and how is it to be exercised? All you're left with if hardship is out is the bare fact of an appeal. And as the question that my Lord Hughes put to my learned friend indicated, it isn't just the bare fact of an appeal, it's the bare fact of an appeal or appeals. He had no answer to why, logically, on his argument, it should stop at the FTT stage. And there is no reason why it should stop on the logic of his argument at the FTT stage. So it's simply the bare fact of appeals with hardship stripped out, with the period lasting indefinitely. How then, on the Court of Appeal's conception, does the discretion that they found in 88C3 work? And my learned friend had no answer to that question. Finally and thirdly, in relation to Section 9, I'm not going to reprise all the same arguments. The course of the exchanges indicated that there were certain difficulties with my learned friend's approach in relation to Section 9. I simply wanted to remind you of a single case to which we referred in our written case, and I didn't take you to orally, which was the public law project case, which will, as you may or may not recall, was about withdrawing legal aid from those who were not resident in the jurisdiction. And in that case, as I recall to my cost, we sought to run an argument that if you couldn't find the power in the base provision, you could probably find it in the incidental part of lapso. And the court was, if I can put it politely, having none of that. And it was having none of that for the reasons set out in the passage we've quoted, and particularly the passage that we've quoted in bold in paragraph 72.3 of our case. And I only draw your attention to that, it's MS page 133, because my Lord Hughes posed the question, what's your best case? Or what's your best case for being able to use an incidental power, in effect, to undermine the primary provisions and an express statutory prohibition? It isn't quite on that, but frankly, if that's the reasoning of the court in that case, it's very difficult to see why, if you're dealing with a statutory prohibition, the reasoning isn't a fortiori. So that's all I wanted to say by way of reply. My Lord, I'm very conscious that we will need at some point to...
Can I, before you go on
Yes,
to this other matter, ask you what you say about Mr. Bednam's last two sentences on his feet, where he suggested that you could, on an interim basis, exclude all sales while the litigation was in progress?
Well, my Lord, it perhaps dovetails with the request for timetabling for the new submissions we're going to put in, because you'll appreciate that the answer to that question may not necessarily be unlinked to the powers that the High Court has. If there is a difficulty with the High Court powers that were identified in the exchanges we had this morning with my Lord Briggs, it is that they may have to go a bit, if I can put it that way, in order to find a power in Section 37 broadly expressed to order the revenue to do something which is actively prohibited by statute. And if the position is that my learned friend Mr. Bednam's last two sentences are accurate, it might be thought that I might want to pray that in aid.
Well, except that it wouldn't be forbidden by statute if it was excluded.
Yes, but
No,
at the moment,
that's my point. I mean, what I'd like to think about in answering that set of questions is whether or not the High Court could. One of the things I'd like to think about.
but as I understand it, you can only currently do it under your current powers by notice, i.e. certain classes of excluded sales. You can't do it on a sort of bespoke basis for each appellant.
I think that's probably right.
Is that an obstacle that can be negotiated?
Right. Yeah, I think that probably is right, but one may be able to fashion something, particularly if one had the rocket fuel of an otherwise breach of Article 6 attached to it. One might be able to fashion something which would allow an order to be made using Section 37 that doesn't as directly cut across,
yes,
and therefore does less damage to the statutory scheme, and that I'm grateful to him. That may be a candidate. But I'd quite like to think about thinking about those broader issues.
We've got to decide the present case on the law as it currently stands, which doesn't include an exercise of the power to exclude sales on the basis suggested. All that one would really be saying is that the scheme might be altered in that respect so as to cure the problem.
Yes, although the power to exclude sales did arrive at a certain point in the history, as you're aware.
Mm-hmm.
Yes, but it has to be exercised by regulation, doesn't it?
It was exercised.
Sorry, by notice.
It was
So the notice that you were taken to 1st of November 2015, I think it was, didn't have 4.5 in it.
That's right.
And the power is in the regs.
As
As I understand it, the power is in the regulations,
the power to prescribe is in the regulations.
but it was a power to prescribe, and then it wasn't until quite
31st
recently
March
that prescription was
2015.
undertaken
But the
on a sort of formulaic basis, as it has to be, if it's a
But
prescription.
you'll appreciate why I want to pause to think about it, because
Yes.
I mean, to some extent, all the focus on, it's an aspect of the same thing, but all the focus on not the 4-5 point, but what the revenue were doing initially,
Yes.
before they had collywobbles, as my Lord Sumption put it, probably entirely accurately. All of that is, to some extent, one might have thought, a sideshow, because what this court is actually interested in is not what the revenue did, or the revenue's own assertion of power. It may be lovely for them to create law by asserting power, but that isn't the way it works. And I don't so assert, even though it might suit me here. But that's a sideshow. The question is, can they, and if so, how, or can the High Court, and if so, how, operate in some shape or form its injunctive jurisdiction so as to do something which doesn't
Cut across the statute.
Exactly, and if they can't do that, well then the fallback submission, no doubt, would be, or perhaps the primary submission would be when we thought it all through, well, it's a jolly strict regime, hard luck.
Yes.
Or
And obviously the use of the
find some
power,
other way.
and the use of the power to prescribe excluded sales would be subject to the usual Padfield constraints.
So it'd be subject to the usual Padfield constraints, and so one may have to address and think about that too. But, I mean, amongst the other things one would have to think about is whether or not you could, because the premise for all of this is that the High Court has otherwise operated properly, pursuant to the Court of Appeal in our case's approach, the CC&C jurisdiction. In other words, it's concluded that there would be an improper restriction on access to court.
Yes.
In those circumstances, the 85 and 86, the claimant gets over that. What now does the court do by way of remedy? Section 37 query its limits, particularly having regard to the abutting legislative regime over on the left-hand corner. But I quite like to think about that.
I can quite see their links, Sir James. The Court of Appeal at paragraph 45 did float exclusion.
It did.
It didn't answer it. It simply said it wasn't surprising it hadn't been exercised.
On a general basis.
Well, that's the point, isn't it? If it was going to work, you'd have to work out how you framed the exclusion, and it would have to be, well, for a start, it would have to be all sales by somebody who's got an appeal, but that I suppose is possible. But more to the point, it might have to be all sales by anybody who has an appeal.
Well, but that would be very strange.
Yes.
Because, because in those circumstances...
License to print money.
The premise for all of it, the reason it would be strange is not
Yes.
because the case that I'm about to put to you on paper is not a thoroughly sound and good case. It is because the premise for all of this is that you're trying to find a problem to the restriction on access to court difficulty. And we know that the starting point for that is the high bar that the Court of Appeal has properly set on the CC&C jurisdiction.
Yes, okay.
And so it may be that the excluded sales solution would, by definition, only need to apply to those people. And all you're actually doing is saying, we, the High Court, can exercise that power driven by a need not to restrict access to court in this very narrow cohort of cases, not in every case that's appealed, but in these ones which have surmounted the CC&C high hurdle. Now what can we do? And the problem my Lord Briggs raised entirely properly is, well, it's a jurisdictional question. Can they actually make an order to give effect?
But what was troubling me was the idea that the court could grant an injunction to do something which is prohibited by the statute, or just outwith HMRC's powers. But the court has, for decades, if not centuries, dealt with the risk of stifling appeals by granting an appropriately bespoke stay on terms which prevent the enforcement of a judgment stifling the appeal. Now, normally it's a stay of execution, but that doesn't work here because this is a self-executing decision. Once you've made the decision, he doesn't go on the register and he can't trade. But I'm wondering whether the court's power to stay, and it regularly stays the effect of a decision without depriving the decision of being something you can appeal about. And it just seems to me that may be worth, and I'm not expecting a response from you now, giving some thought to whether within that inherent power it really is just limited to a stay of execution, or whether it's limited, or whether it can extend to a stay of any consequences of the decision, so that here the decision wouldn't have been made by the revenue, and therefore the regime wouldn't have cracked in on this particular wholesaler.
Yes, and the logic of that is you can avoid thereby crashing into the rock that is the legislative scheme.
And it can still be bespoke, and it can still be on terms, so that it doesn't form a basis of abuse.
Maybe think about that too.
Yeah, I mean, it may lie in the difference between staying a decision of a court is one thing, staying the operation of a statute, if that's what it involves, but only if, might be rather different.
I'm not saying it's problem-free.
No. Well, we'll all have to think about those, but there's a timetable.
Yes, do you have an opening bid?
I've got a bit of a busy July, is my opening statement.
Yes.
I'm seeing you,
I think from the point of view of the court, there's no particular rush.
No. I mean, and again, we haven't really thought about whether it should be consequential or exchanged, one round, and all of that. I mean, it may be that the court has thoughts about that, but I, from my entirely selfish perspective, wouldn't mind a bit of August to have a think about that. I mean, the court presumably isn't going to be producing a judgment any time before it reconvenes in October.
No.
So if we did an end of August for me and end of September for you, I don't mind. I mean, sequential feels more sensible.
Yes.
My Lord, I mean, as ever, we're in your hands.
Yeah. Yes. If the parties are content with that proposal, end of August, or perhaps if you were to exchange at the end of yours with Mr. Coppell by the end of August, and then they both came in at the end of September, that would be fine for us.
So 2 rounds.
Yes.
I don't mind.
I mean, if you've both had a chance, if you've both had an opportunity to read what the other has to say at your initial stab at it,
right,
and respond to that.
Then we do it.
In other words, if you were to exchange, say, by the end of August, and then to give the court your final version by
So there's a single version would be filed, i.e. the first version wouldn't be referred to. I understand that. Does it make sense for some agreement on how wide this should go in the formula of words? Because I'm fearful that there are a lot of issues actually going down there, and your lordship and your lady are going to get yet another sizable document unless we're more than careful to constrain the bounds.
You originally wanted to challenge CC&C, didn't you? But the issue that we're currently on is not actually that at all.
No, it's CC&C is sort of sitting there on the side and snapping at our heels.
Yes.
But
it's really the implications of the construction of Section 88C, for which the revenue are arguing, for the ability of the court to grant an injunction in the form in which it was granted by the...
So if we are correct, what is the impact on the court's jurisdiction under Section 37? Is what you're interested in.
Yes, that's right.
So are you happy with that? Yes.
Could I possibly offer a sort of more abstract formulation, and that is whether the High Court has power to grant an injunction to allow a person to wholesale in circumstances where the revenue has no power to allow that person to wholesale.
Well, that's the same question that has just been formulated.
And I wouldn't want it constrained by injunction.
With too many limitations on it. Yeah. I mean, basically, one will need to review a wide range of possibilities, so artificially limiting the form of the question may well get in the way, has a habit of doing so.
It's effectively, isn't it, has the High Court got power necessarily under any particular place, but has it got power effectively to grant a stay as a matter of discretion to a would-be to an appellant pending his appeal?
I think your formulation is less question-begging than any of the ones that have been canvassed.
I don't think there's going to be a great deal of difficulty in either side targeting it. If we're aiming at the wrong target, you'll ignore it.
Yes,
Yes, well, that's fair enough.
If you do find you're in any difficult uncertainty about the scope of this exercise, do revert to the court for guidance. But I think we've given you a pretty clear idea of what the area is that we're looking for assistance on.
Certainly, we're grateful.
Well, thank you. Well, the court is very grateful to counsel on both sides for, if I may say so, excellent submissions, and grateful also to all others who've been involved in the preparation of the appeal and cross-appeal. We'll await your further submissions, but we might start thinking about this in the meantime, and we'll issue our judgment in due course.